Welcome to Middle Class Matters, Business News in English from Dr CMA Alagesan on the CAG report number 19 of 2023 on Bharatmala Pariyojana road project. Scam of rupees 7,50,000 crore in the road projects done by Government of India. Part number 32. Besides non-levy of commensurate penalty on concessionaires for delayed achievement of financial close, such a delay also resulted in late fixation of appointed date with resultant delay in progress of the project. MORTH assured in April 2022 that audit observation would be reviewed to ascertain the detailed justification for imposition or non-imposition of damages as per concession agreement, and the factual position would be intimated in due course of time. 6.3.2.2 Harpur Bypass Moradabad. NHAA worked out damages to the tune of 39.45 crore for concessionaires' delay in submission of performance bank guarantee by 120 days and delay in achievement of financial close by 99 days. However, the same was not levied on the concessionaire due to mutually waived off the same, as NHAA also failed to provide requisite right of way on the appointed date. MORTH replied in April 2022 that NHAA was at fault of not handing over of right of way and only 70% would be provided till appointed date. Therefore, no damages were levied upon concessionaire by mutually waiving of the same. Reply of MORTH may be viewed against the fact that fulfillment of condition precedent by NHAA and the concessionaire were independent of each other, and as per extent of relative fault of both parties, damages should have been computed and levied or paid in compliance to concession agreement rather than squaring them off. Recommendation number 28. Compliance to preconditions for fixation of appointed date needs to be strictly adhered, and any non-compliance by either party to the contract needs to be accounted for as per contractual provisions. 6.4 Environmental Conservation and Phase 1 of Bharatmala Pariyojana. 6.4.1 Environmental Clearance and Diversion of Forest Areas for Phase 1 of Bharatmala Pariyojana. The legal framework for protection of environment and wildlife consisted of Environment Impact Assessment Notification of 2006, Forest Conservation Act 1980, Coastal Regulation Zone Notification 2011, and Wildlife Protection Act 1972. Environment Impact Assessment Notification of 2006 required national highway projects to obtain prior environmental clearances from Ministry of Environment, Forest and Climate Change, who would give environmental clearance based on the recommendation of Expert Appraisal Committee constituted by central government. Hence, exercising of powers under Environment Protection Act 1986 and Environment Protection Rules 1986, MOEFCC, issued 14 September 2006 as amended from time to time, guidelines regarding obtaining of environmental clearance prior to undertaking highways construction, as per which environment clearance was mandatory for the following: construction of new national highways or expansion of national highways greater than 100 km involving additional right of way or land acquisition greater than 40 km on existing alignments and 60 meter on realignment or bypasses. As per Forest Conservation Act 1980, for every project requiring diversion of designated forest land for non-forestry purposes, forest clearance was to be obtained from MOEFCC. The Forest Conservation Rules 2003 provided the procedure to obtain forest clearance, as per which it was to be granted by MOEFCC under two stages, that is, stage 1, in principle approval granted pending final approval subject to certain conditions, and stage 2, final approval for highways projects passing through protected areas, national parks and wildlife sanctuaries. Further consultation with National Board for Wildlife, State Board for Wildlife was required under Wildlife Protection Act 1972 before any approval. MORTH, while its standing operating procedures, to December 2017 made it mandatory for detailed project report consultant to get the environmental clearance and forest clearance for any project before the project was approved by the competent authority. Audit, while reviewing 66 sample projects, observed the following regarding environmental clearance and forest clearance for the sample projects. The provisions of EPC, HAM and BOT toll agreements regarding the time by which environmental clearance and forest clearance were to be obtained for the project was at variance with BPP-I standard operating procedure issued by MORTH, as the requirement of environmental clearance and forest clearance was diluted in these agreements. As per EPC agreement, the environmental clearance was to be obtained prior to issuance of letter of award, and regarding forest clearance, the forest land being part of right of way, timeline for forest clearance could be stretched at least up to appointed date. In case of HAM projects, the environmental clearance and forest clearance were conditions precedent to be fulfilled by implementing agency before fixation of appointed date, whereas BOT toll agreements were silent regarding timing for obtaining forest clearance. However, environmental clearance has been made a condition precedent. MORTH failed to adhere to environmental clearance guidelines of MOE FCC and failed to develop uniform directions or practices to be followed for obtaining environmental clearance for national highways projects as observed in following instance. Though BPP-I was planned on the basis of corridor approach, as the package or project-based approach of NHDP was found to be deficient by MORTH while deciding on requirement of obtaining environmental clearance. MORTH and its implementing agencies considered smaller package lengths instead of whole corridor. Impact on environment due to planning of such long corridors should have been analyzed in totality rather than analyzing by considering requirements of environmental clearance for individual packages. In case of 23 packages out of 66 sample projects, audit observed that the requirement of environmental clearance was skipped by adopting package-based approach as against corridor-based approach, including that for eco-sensitive northeast region, while determining requirement of environmental clearance as detailed in Annexure 10. In case of Greenfield Delhi-Mumbai Expressway, instead of taking environmental clearance for Delhi-Vadodara Expressway and Vadodara-Mumbai Expressway as a whole, environmental clearance was obtained separately for each state, forming part of project length in case of Delhi-Vadodara Expressway, while in case of continuous stretch of Vadodara-Mumbai Expressway, environmental clearance was obtained phase-wise, wherein highway length was passing through 3 states and union territory in phase 1 alone. For Dwarka Expressway, in spite of it being a new national highway, no environmental clearance was obtained. And Solapur-Bijapur project with a length of approximately 109 km was awarded on BOT mode in the year 2012 but was terminated due to non-fulfillment of condition precedent of environmental clearance. The project was taken up fresh in the year 2017 under BOT toll mode in BPP-I in spite of no environmental clearance obtained for this project. Standing Cost Committee, chaired by Additional Secretary and Financial Advisor of MORTH, was apprised 13th December 2016 by NHAI that environmental clearance has already been obtained for the project. However, in response to Public-Private Partnership Appraisal Committee PPP-AC query on environmental clearance, MORTH replied on 16th January 2017 that environmental clearance was not required on the ground that the entire stretch was falling in 2 states, that is Maharashtra and Karnataka, and the project at length lesser than 100 km in each state. PPP-AC directed MORTH to take up the matter with MOE FCC before approval of the project. However, nothing on record was found regarding NHAI obtaining such clarification from MOE FCC before approval of the project. MORTH replied in April 2022 that Solapur-Bijapur was a widening project from 2 lanes to 4 lanes with additional land acquisition being less than 40 meters on existing right of way and less than 60 meter in the realignment or bypasses. Hence, MOE FCC guidelines were not applicable on this project. For other issues in the observation, no reply was furnished by MORTH. Reply of MORTH may be viewed against the fact that as per the MOE FCC guidelines, environmental clearance was mandatory for expansion of national highways with a length of more than 100 km irrespective of land acquisition done for expansion. While reviewing 45 sample projects in which forest clearance stage 1 and 2 was required prior to approval of project, audit observed in February 2022 the following. Stage 1 forest clearance could be obtained only for 6 projects prior to approval of projects by competent authorities, while rest of 39 projects, the details of stage 1 project clearance were as follows. Stage of completion, number of projects, range of delay. Approval of the projects 5 to 393 days delay. Issuance of letter of award 20 projects 1 to 607 days delays. Appointed date 13 projects 3 to 731 days delays. Pending till 2022 to total is 39. Similarly, the stage 2 forest clearance was obtained only in one project, that is balance work on Bareilly Sitapur prior to approval of the project by competent authority. While by for balance projects, the details of stage 2 project clearance were as follows. Approval of the project nil. Issuance of letter of award 240 days to 284 days delay. Pending till February 20, appointed date 27, 5 to 1448 days delays. Pending till February 2022, 13 projects, total 44. In 13 sample projects, out of the above 45 projects for which provisional completion certificate PCC was issued up to February 2022, no stage 2 forest clearance has been obtained in case of 3 such projects detailed below till February 2022. While in case of another 2 projects, stage 2 forest clearance was obtained after a period of approximately 8 months to 2 years of issuance of PCC of such projects. In 8 sample projects, due to non-obtaining of forest clearance before approval or award of project, either the overall project execution or completion was delayed, or the alignment passing from such forest area was being de-scoped, resulting in non-achievement of origin destination connectivity and seamless movement as envisaged for BPP-I. Thus, BPP-I projects in many instances were being implemented in contravention to MOE FCC guidelines and MORTH standard operating procedure directing pre-obtaining of environmental clearance and forest clearance before the project approval. Further, due to not obtaining the forest clearance prior to approval of the project, either the affected project stretches were being de-scoped with no alternate arrangement, or project progress was getting stalled, thereby hampering the progress of Bharatmala pariyojana projects. MORTH did not furnish reply to the audit observations. Recommended number 29. The model EPC concession agreements need to be reviewed and synchronized in line with MORTH standing operating procedures and MOE FCC guidelines. Recommendation number 30. Environment impact assessment and environmental clearance need to be obtained for entire corridor rather than for small packages of long corridors, and guidelines regarding obtaining environmental clearance for national highway projects in line with MOE FCC guidelines may be codified. 6.4.2 Usage of fly ash in phase 1 of Bharatmala pariyojana projects. Besides prior to environmental clearances, MOE FCC also notified guidelines 25th January 2016 in regard to mandatory usage of fly ash in national highways construction from any thermal power plant within radius of 300 km of the road project. MORTH notification dated 27th August 2018 issued directions to NHAI and other implementing agencies for compliance of the same. The status of fly ash generation from National Thermal Power Corporation Limited plants all over India, and its usage during the period 2016-17 to 2021 is as follows. It may be seen from the bar chart that in spite of availability of surplus fly ash during 2017-18 to 2021 in the range of 145.17 LMT to 297.03 LMT, no memorandum of understanding MOU was signed between MORTH or NHAI and the Ministry of Coal or NTPC for release of dedicated quota of fly ash to the implementing agencies of MORTH to effectively utilize fly ash and mitigate environmental damage. Rather than centrally arranging fly ash as NHAI headquartered level, it has been made the duty of individual project implementation units to arrange fly ash for the projects, and in the case of NHI DCL, there was not even assignment of such responsibility to anyone. Please like the video, subscribe to the channel, please share it to the people, because we are the tax paying people who must aware of how our tax money is being swindled by the politicians, contractors and the executives who are involved in the in this road construction activities, and we must be aware of this. Then only we will be able to protect our interests. Thanks for watching.